Florida gun owners thought they had finally caught a break in 2023. But here's the thing, it was only half the meal. We were served just enough to feel like we were sitting at the table, but the plate wasn't full. And now the question hanging in the air is whether Florida is finally about to finish the job, or if this so-called Gunshine State is content with playing pretend. Florida sells itself as a place of wide-open freedom, a state where liberty is stitched into the flag and where personal rights supposedly take center stage. That branding gets pushed hard, and I get why. Sunshine beaches, palm trees, and a strong gun culture that goes back generations on the surface, it fits the picture. But peel back that postcard image, and the rulebook looks a whole lot messier. In 2023, Governor Ron DeSantis signed HB 543, the law that made permitless concealed carry the rule of the land starting July 1st. That move made Florida the 26th state to drop its licensing requirement for concealed carry, and on paper it sounded like a huge win. For years, folks had been grumbling about having to fork over money, jump through hoops, and wait weeks just to get a little card in the mail that let them carry what was already their right. And when the governor finally put pen to paper, it felt like freedom was finally here. But here's the catch. HB 543 didn't rewrite the rules for buying a firearm. You still have to be 21 years old. You still have to pass a background check when you buy from a licensed dealer. And if federal law says you can't own a gun, nothing about that changed. It didn't erase waiting periods. It didn't blow open who could legally possess a gun. What it did was strip away the state-issued permission slip for concealed carry. That little plastic card in your wallet. That was the headline. And to be fair, it was a big change compared to the way things used to be. Before 2023, if you wanted to carry concealed in Florida, you had to pony up close to $100, sit through a mandatory class that felt more like a bureaucratic box check than real training, get fingerprinted like you were applying for a government job, and then wait. Weeks could go by before that card finally showed up in the mail, and only then were you allowed to carry. So when HB 543 passed, plenty of Floridians felt like they were breathing free air for the first time. They didn't have to keep begging the government for a laminated hall pass just to exercise a right. Compared to states like Georgia and Alabama, where folks had already been walking around without that kind of restriction, Florida finally felt like it was catching up. And for gun owners, it was a moment worth celebrating. But don't get it twisted, this wasn't a blank check. The law's limits became clear the minute people asked the obvious question, can I carry openly now? The answer was, and still is, a hard no. HB 543 didn't touch open carry. If anything, it highlighted just how restrictive Florida still is when it comes to carrying your firearm where everyone can see it. That's where the frustration sets in. Because while Florida was patting itself on the back for joining the Constitutional Carry Club, it was really only half a member. The other half, the open carry half, was still locked out. And it doesn't take a legal scholar to see the contradiction. On one hand, you can tuck a pistol under your shirt and walk down the street, no license required. On the other hand, let that same pistol print a little too much through your shirt, or heaven forbid you wear it outside the waistband at a gas station, and suddenly you're on the wrong side of the law. That's why so many people call this halfway freedom. Sure, Florida made progress in 2023, but the daily reality hasn't caught up with the Gunshine State reputation. You can carry, but you better keep it hidden. Step outside those lines and you're risking a criminal charge. That kind of halfway policy doesn't exactly scream liberty. It whispers compromise. And here's the thing, Florida isn't some lonely outlier on this. Before HB 543, the state had one of the biggest pools of concealed carry permit holders in the nation, millions of people carrying that little card. They all knew the same frustration. They all looked across the border at states like Alabama and Georgia, where no such permit was needed, and asked why not us. HB 543 finally answered that question, but only halfway. So here we are. On July 1st, 2023, permitless concealed carry officially became law. It was a victory, no doubt, but a victory with an asterisk. And if you're wondering why gun owners didn't break out the champagne for long, it's because they knew the job wasn't finished. Open carry was still off the table, the red flag law was still in place, and Florida was still playing dress-up as the Gunshine State without fully living up to the name. So here's where Florida trips over its own boots. We got permitless concealed carry, sure, but the idea of actually carrying openly out in the daylight still sits squarely in the illegal column. That's not me exaggerating. Unless you're fishing, hunting, camping, or traveling directly to or from one of those activities, the law says you better keep it hidden. Otherwise, you're breaking the law, plain and simple. And I don't mean restricted in certain buildings or banned in sensitive zones like airports or schools. I mean banned across the board. You walk into a gas station with a pistol riding on your belt, no criminal record, clean as a whistle, and you're suddenly in violation. That contradiction is what keeps eating at people. Because if you can legally tuck a handgun under your shirt without a permit, why should it be criminal to wear the same gun openly in a holster? It's the same weapon, the same owner, the same background check that cleared the purchase, but the state draws an arbitrary line in the sand. Keep it covered, and you're fine. Let it show, and you're in trouble. That isn't freedom, that's dress code politics. And that's why a lot of folks saw HB 543 not as the end of the road, but as the beginning of the next fight. Enter HB 31, filed in December 2024 by Representative Joel Rudman. His bill went straight at the heart of Florida's contradictions. It wasn't just about fixing the open carry ban, though, that was front and center. It also aimed at ripping the red flag law out of the books. In other words, HB 31 tried to do what HB 543 started, turn Florida into a true constitutional carry state, where people could decide for themselves whether to carry concealed or openly without fearing the hammer of the law for a pistol on their hip. For supporters, HB 31 was the missing piece of the puzzle. Without open carry, constitutional carry is constitutional in name only. It's like telling people they're free but then dictating how they have to exercise that freedom. The bill promised to tear off the last set of chains let Floridians carry as they saw fit and finally match the reputation with reality. Gun rights groups cheered it on, calling it the natural next step after HB 543. But here's the harsh truth: politics is rarely that clean. HB 31 ran straight into a wall, and that wall wasn't built by Democrats in California or lobbyists parachuting in from out of state. It was built right here in Florida by sheriffs and Republican leaders who decided they weren't on board. The Florida Sheriff's Association dug in its heels, insisting that open carry would scare the public and tie law enforcement's hands. They painted pictures of chaos, families panicking at the sight of a holstered gun, officers struggling to tell good guys from bad guys. And they weren't alone. Senate President Ben Albritton, a Republican, no less, went on record saying he didn't support open carry. Think about that. Even with a Republican supermajority in Tallahassee, the brakes got slammed by the very people voters thought were pro-Second Amendment allies. By January 2025, the writing was on the wall. HB 31 was withdrawn before it could even move forward. The dream of finishing the job HB 543 started got shelved, and gun owners were left staring at the same halfway reality. Concealed carry without a permit. Yes. Open carry, still no. Red flag law, still on the books. The Gunshine State still stuck in the awkward middle, bragging about freedom while wearing handcuffs under the table. If open carry is the obvious battlefield, the red flag law is the landmine hiding just beneath the surface. Florida put that law on the books back in 2018, right after the Parkland shooting, when emotions were at a fever pitch, and lawmakers felt cornered into doing anything. What they came up with was a risk protection order, a legal shortcut that lets a judge sign off and allow police to temporarily seize your firearms if someone convinces the court you're a danger to yourself or others. On paper, it sounded neat and tidy, protecting the community keep guns out of the wrong hands. In reality, it became a tool ripe for abuse. Think about it. All it takes is one phone call from an angry ex, a neighbor with a grudge, or even a worried family member, and suddenly you're standing in front of a judge defending your right to own property you legally bought. No crime committed, no charges filed, just a piece of paper and your guns are gone. That flips due process upside down. Instead of proving guilt before punishment, the punishment comes first and you fight to claw your rights back afterward. Gun owners saw it for what it was: an easy path for the government to take without the hard work of proving someone actually broke the law. Supporters of the red flag law argue it has saved lives. They point to thousands of petitions filed since 2018 and cases where unstable individuals were kept from doing harm. Law enforcement groups hold it up as a preventive tool. But the clash is unavoidable: safety on one side, constitutional rights on the other. HB 31 tried to pull that law out by the roots. To many Floridians, that wasn't extremism, it was restoration. If someone truly poses a threat, there are already laws to handle it, from involuntary commitment to criminal prosecution. You don't need to strip away rights first and sort it out later. And yet, the strongest opposition to open carry and the repeal of red flag laws hasn't come from Washington or coastal liberals. It's come from inside Florida itself. The Florida Sheriff's Association has been pounding the table against open carry for years, warning it would sow panic in public places and create headaches for officers. They roll out the same line that seeing someone with a gun on their hip will spook families at the grocery store and make law enforcement's job impossible. As if Floridians haven't been around firearms their whole lives. As if the sight of a holstered pistol is some shocking new phenomenon in a state where rifle racks are a common accessory in truck windows. And the real sting, many Republican leaders in Tallahassee have taken cover behind those sheriffs. Senate President Ben Albritton himself admitted he didn't back open carry. So even with a Republican supermajority, the brakes are slammed by the very people who claim to stand for the Second Amendment. For everyday gun owners, it feels like betrayal. They delivered the majority, they celebrated HB 543, and now they're told they can't be trusted with a holstered pistol in public. That's not leadership, that's cowardice. So here's where Florida stands at a fork in the road. HB 543 in 2023 gave a taste of freedom, but only half. Open carry is still banned. Red flag laws still bind, and constitutional carry is constitutional in name only. If HB 31 had survived, Florida would have leapt from halfway free to wide open, setting the national standard alongside Texas and Arizona with the added notch of rolling back red flag laws. But with HB 31 withdrawn, nothing changed. Florida remains in the awkward middle, bragging about liberty while shackled by contradictions. The choice couldn't be clearer. Either Florida shakes off the last of these chains and finally earns the Gunshine State title, or it keeps pretending strutting around halfway free while other states pass it by. That's the cold, hard truth.